I rise to speak on the cognate debate with specific reference to the Criminal Code and other legislation, Double Jeopardy exception and subsequent appeals Amendment Bill 2023. The bill has been introduced in response to the 2022 report by Walter Sofronoff, KC, following his inquiry into the forensic DNA testing in Queensland. The Commissioner made a number of observations and findings relevant to the consideration of any reform of Chapter 67 and 68 of the Criminal Code. Importantly, it was found that the methods, systems and processes used at the forensic DNA laboratory do not in many ways measure up to the best practice standards, and the Commissioner highlighted that the laboratory's focus on turnaround times was driven in a large part by chronic underfunding. The Commissioner commented that these issues of underfunding were well known at the highest levels of Queensland Health, and the Queensland Government as far as back as early as 2005. As the Commissioner identified, the totality of these failings have had serious negative ramifications for the criminal justice system, and there is no doubt that the failure to obtain all of the evidence available from samples has affected some and many cases. In most cases, it may have reduced the prospects of conviction by failure to obtain evidence which could support a complaint. It is possible but unlikely that the failures could have resulted in the wrong conviction. The number of cases actually affected and whether it's different processes, those cases would have resulted in different outcomes, have never been properly quantified, Deputy Speaker. The bill introduces a subsequent right of appeal for convicted persons who have exhausted their original right of appeal, and under the new framework, a convicted person may make a subsequent appeal against their conviction if there is fresh and compelling evidence or new and compelling evidence relating to the offence. I strongly support the introduction of another legislative pathway for defendants who have already unsuccessfully appealed to the Court of Appeal but then come into possession of further evidence. And currently, the only remaining avenue available to a convicted person after exhausting the original appeal process is to petition the Governor for a pardon. And a person cannot make a subsequent appeal against a conviction to a Court of Appeal, even if evidence later emerges indicating the person is innocent. And the bill also contains amendments enhancing the state's ability to respond to possible unjust acquittals by expanding the offences to which the fresh and compelling evidence double jeopardy exception applies. The term double jeopardy refers to the long-standing criminal law principle that a person cannot be retried for an offence for which they have already been convicted or acquitted. The explanatory notes provide the following rationales for the rule against double jeopardy. A person should not be harassed by multiple prosecutions about the same issue, the need for finality in proceedings, the sanctity of jury verdict, the prevention of wrongful convictions, and the need to encourage investigators and prosecutors to be efficient in putting forward their best case. I'm opposed to the bill's further watering down of the double jeopardy rule, which would expand the offences to which double jeopardy exception applied. And the current exceptions are sufficient for maintaining public confidence in the state's criminal justice system whilst continuing to uphold fundamental legal principles. The bill's changes have been linked to the findings of forensic lab inquiry. However, once enacted, its effect will not be restricted to any cases emanating from the inquiry. And the bill changes will apply to all matters involving offences engaged by the new provisions. And this is what is known as mission creep. And it's one reason I support the introduction of a further appeal right for a defendant, but opposes the relaxation of the rule for the Crown because there's a different set of considerations at play. Defendants can have defective trials and appeals which are effectively no fault of their own, whereas the Crown should be bound by its forensic decisions, its approach and its ethics at a trial because it is in a better position and the other side is a single individual against the might of the Crown. Furthermore, it is also important to acknowledge that the current rule against double jeopardy does not affect the prosecution's ability to bring a charge in circumstances where charges against a person have never been laid or charges against a person were laid but then later discontinued. The rule against double jeopardy works hand in hand with the principle of finality in criminal law, which is important to the proper and economical allocation of public resources. At its core, however, the rule against double jeopardy is also fundamental control on state power, given that in every case the power and resources of the state will be greater than those of an individual accused of a crime. The fundamental nature of the rule against double jeopardy within Australia's criminal justice system is recognised by Section 34 of the Human Rights Act 2019, which provides a person must not be punished more than once for an offence in relation to which a person has already been finally convicted or acquitted in accordance with law. In this way, the rule against double jeopardy encourages efficient police investigation safeguards against the use of prosecutions as a tool of state oppression, and it acts as a bulwark against repeated attempts to subject an accused to the criminal justice process. Double jeopardy serves to maintain confidence in the criminal justice system in a way that is too easily underestimated. And the state has many advantages over a defendant in a criminal trial, including greater resources and powers to conduct investigations. The prosecution in criminal offence starts from the advantage that many jurors will say if there was nothing in this case, the police would never have brought it. The criminal justice system rectifies those imbalances by presumption of innocence and placing the burden on the prosecution to prove the offence beyond reasonable doubt. In addition, this attempt to correct the imbalance is supported by the rule against double jeopardy. Once acquitted, a person could leave the courtroom with the prospect of rebuilding their life, and this looks like it's no longer the case. If this bill is enacted, the prospect of their being charged again will hang over their head, most likely for the rest of their lives. Thank you, Speaker.